Good day, everyone. So today we will discuss the Labor Code of the Philippines. And our topics focus on labor law and standards, basic pay, overtime premium, night shift differential, holiday premium, 13th month pay, leaves, service incentive leave, maternity leave, paternity leave, and lastly, parental leave for solo parent. So first, let us tackle what is labor law and labor standards. So, labor law is a Presidential Decree number 442 known as the Labor Code of the Philippines. And this code shall take 6 months after its promulgation. It was enacted in sometime in November 1974 and took effect in May 1, 1974, which is the Labor Day. This was drafted by Blas Ople, a former Secretary of Labor of the Philippines, under the umbrella of former President Ferdinand Marcos. Moreover, the Labor Code has two books, but in this discussion, we will only discuss the book 1, which is the Labor Standards. So what is labor standards? Labor standards, these are the laws which set out the minimum requirements prescribed by existing laws, rules and regulation relating to wages, hours of work, and cost of living allowance, and other monetary and welfare benefits, including occupational safety and health standard. It is legally mandated benefit. It means that it is required by law to be given such that if a law says that this benefit should be given to the employee, then it must be given to the employee without any other conditions or requirements that will be coming from the employer. So, public policies declared by the state, which is the Republic of the Philippines under the Labor Code. These are the basic policy of the state according to Article 3. The state shall afford protection to labor, promote full employment, ensure equal work opportunities to all people regardless of sex, race, or creed, and regulate the relations between workers and employers. Also, the state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just and humane conditions of work. Security of tenure and just and humane conditions of work, these are labor standards law. Security of tenure in labor law refers to the protection of an employee's right to continue their employment without unjustified termination, and it ensures that employees cannot be fired without valid reasons and due process. This helps provide stability and job security for workers, while just and humane conditions in labor law refer to the legal requirements for employers to provide fair and decent working conditions for their employees. This includes ensuring fair wages, reasonable working hours, safe and healthy workplaces. On the other hand, under the Constitution, which is the basic law of our land, now we are currently using the 1987 Constitution, which was ratified by the people, and there are basic rights granted by the Constitution to workers, and these are the following: the right to organize, the right to conduct collective bargaining or negotiation with management, the right to engage in peaceful concerted activities including strike in accordance with law, the right to enjoy security of tenure. This pertains to the safety of a worker or of his employment, the right to work under humane conditions, the right to receive a living wage. Wage is governed under the minimum wage law, so most of the workers are receiving minimum wages. And lastly, the right to participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. This pertains to the formulation of employee handbook, employees' conditions while being hired by the company. So the first three rights are labor relations law, and the rest are the labor standards law. Furthermore, there are principles which made under the labor law, The first principle is construction in favor of labor. All doubts in the implementation and interpretation of the provision of this code, including its implementing rules and regulation, shall be resolved in favor of labor. Construction means the interpretation of the law, so when there is doubt, then it should be resolved in favor of labor. And if there is no doubt in implementing and interpreting the law, labor will be enjoy no built-in advantage and the law will have to be applied as it is. Second principle is gives a right to management, the right to conduct business, the right to prescribe rules, select employees, and transfer or discharge employees. Then the last principle is the management prerogative. Except as limited by special laws, an employer is free to regulate, according to his own discretion and judgment, all aspects of employment. That is including hiring, work assignments, working methods, time, place, and manner of work, tools to be used, processes to be followed, supervision of workers, working regulation, transfer of employees' work supervision, layoff of workers, and discipline, dismissal, and recall of workers. Therefore, as long as the management prerogatives are exercised in good faith for the advancement of the employer's interests and not for the purpose of defeating or circumventing the rights of employees under special law or under valid agreements, it shall be upheld. And the management is given the prerogative, so this is the balance, the construction of law, which is in favor of labor. So this time around, the management is given the right to regulate how they run the business, including how to supervise workers. So now let us talk about who enforces labor law and to whom it may apply. Under Article 5, rules and regulations of the labor law are being implemented by the Department of Labor and Employment or DOLE and other government agencies charged with the administration and enforcement of this code, or any of its parts shall promulgate the necessary implementing rules and regulation. And such rules and regulations shall become effective 15 days after announcement of their adoption in newspaper of general circulation. However, the labor law clearly does not apply to every worker. There are certain workers who are not covered under this law. So firstly, who applies the labor law? According to Article 6, all rights and benefits granted to workers under this code shall, except as may otherwise be provided herein, apply alike to all workers, whether agricultural or non-agricultural, including employees in a government corporation incorporated under the Corporation Code. So, the purpose of the provision intended to encourage workers to seek employment in agricultural enterprises instead of migrating to already crowded urban areas to find work in industrial establishments. Then, who are the workers not covered under the labor code? First, we have the government employees, including those under the employment of government-owned corporation or GOCC, which are governed by the Civil Service Law. Second, managers or those occupying higher ranks, including confidential employees, management or administrative staff, and members of the family of the proprietors. Third, we have the working scholars of schools, colleges, or universities. Fourth, ambulant vendors, domestic servants like helpers or drivers. Ambulant vendors are individuals who sell goods or services in public places, typically moving from one location to another. And those paid by commission, piece rate, or result of task finish. We also have drivers of jeepney or taxi cabs renting the vehicle. We also have the employees of foreign governments or international organizations. Resident physician of hospital who are covered by a training agreement or under a training program accredited or approved by appropriate government agency. We also have the contractual employees as to principal but not to the contractor. And lastly, those who are working away from the office with hours of work in the field cannot be determined with reasonable certainty. That's all for my part, and the current labor standards will be further discussed by my groupmates. Thank you.
In continuation of our topic, I'm Aubrey Danunukid and I will be discussing about the basic pay. So, according to the Labor Code of the Philippines, Title 2, which is the wages. So, in definition of wage in Article 97, so wage is the remuneration or earnings, however designated, capable of being expressed in terms of money, whether fixed or ascertained on a time, task, piece, or commission basis or other method of calculating the same, which is payable by an employer to an employee under a written or unwritten contract of employment for work done or to be done or for services rendered or to be rendered, and includes the fair and reasonable value of board, lodging, or other facilities customarily furnished by the employer to the employee. According also to the Article 97, the definition of labor is that if there is no work performed by the employee, there can be no wage or pay unless the laborer was able, willing, and ready to work but was prevented by the management or was illegally locked out, suspended, or dismissed. So, sa madaling salita, if ang tao ay walang work or there is no work performed by the employee, so wala tayong pay na makukuha or wala tayong wage na makukuha. So here, based on the illustration, we also define what is wage and what is salary. So wage is the compensation for manual labor. However, in salary, it denotes higher degree of employment. And in wages, it is not subject to execution, but the salary is subject to execution. So here we also differentiate the facilities and the supplements. So facilities are the items or expense necessary for the laborers and his family's existence and subsistence, while on the other hand, supplements constitutes extra remuneration or special privileges or benefits given to or received by the laborers over and above their ordinary earnings wages. So facilities are part of the wages, while supplements are independent of the wages. And also the facilities are deductible from the wage, but the supplements are not wage deductible. So, what are the samples of facilities ba? So, samples of facilities are such the use of company's equipment, such as computers, laptops, or cars that is given to you by the company. On the other hand, supplements, examples of supplements are the health insurance, the retirement plans of the employees. So now we have a little knowledge about what is wages all about or what is the pay all about. So here in chapter 2, we'll be discussing what is minimum wage rates. So according to Article 100, prohibition against elimination or diminution of benefits. So the legal requisites before facilities can be deducted from the employee's wages are the three. So the first one is proof that such facilities are customarily furnished by the trade. Second, the voluntarily accepted in writing by the employee. And the third one is the change at fair at reasonable value. So we have the non-diminution rule. So according to this, the benefits being given to the employees cannot be taken back or reduced unilaterally by the employer because the benefit has become part of the employment contract, written or unwritten. So this rule is applicable if it is shown that the grant of the benefit is based on the express policy, has ripened into the practice over a long period of time, and the practice is consistent and deliberate. The third one is, it is not due to an error in the construction or application of the doubtful or difficult question of law. So, but even in the cases of error, it should be shown that the correction is being done soon after the discovery of the error. So here, we also define what is bonus under the Article 100. So bonus is a supplement or employment benefit given under a certain conditions, such as a success of the business or greater production or output. As a rule, it is an amount granted voluntarily to an employee to his industry and loyalty which contributed to the success and realization of profits of the employer's business. Therefore, from a legal point of view, it is not a demandable and enforceable obligation unless it was promised to be given without any condition imposed for its payment. As such, it is deemed part of the wage. So the form of these bonuses is like the Christmas bonus, the mid-year bonus, the profit-sharing payments, and other cash bonuses amounting to not less than the 1/12 of its basic salary. So here, it must always be in the form of legal tender. Like for example, free rice, electricity cash, stock dividends or other bonuses that the company will provide to the employees. So in order to know what is the basic pay of an employee, in Article 101, we also have the category of the payment by results. So payment by results refers to the workers who are compensated based on the number of pieces or products they produce, rather than receiving a fixed hourly wage or salary. So piece rate work is common in certain industries where productivity can be easily quantified, such as manufacturing or agriculture. So labor law in the Philippines provide regulations to ensure that the piece rate workers receive fair compensation and protected from exploitation. So there are two categories of piece rate workers. Firstly is those who are paid piece rates as prescribed in piece rate orders by the DOL. Second is those who are paid output rates which are prescribed by the employer and are not yet approved by the DOL. So the benefits payable to the piece rate workers are identified. So first is the applicable statutory minimum daily rate. Second is the yearly service incentive leave of 5 days with pay. Third is night shift differential pay. Fourth is holiday pay. Fifth is meal and rest periods. Sixth is overtime pay. It is conditional. Seventh, the premium pay, also conditional. 8 is the 13th month pay. And lastly, other benefits granted by law, individual or collective bargaining agreement, or company policy or practice. So let's move on to the chapter 3 of wages, which is the payment of wages. So according to Article 102, there are forms of payments. So here, the employer cannot pay his workers by means of these 7 categories. First is the promissory notes. Second is vouchers. Third is coupons. Fourth is tokens. Fifth is tickets. Sixth is cheats. And seventh is any other objects. So as a general rule, payment must be in legal tender. As we all know, legal tender refers to currency that is recognized by the law as valid for settling financial obligations, including debts and purchases. Moreover, according to Article 103, when will be the employer must pay or shall pay. So according to Article 103, the time of payment is that at least once every 2 weeks or twice a month at intervals not exceeding 16 days. So here, force majeure or other circumstances beyond the employer's control, payment must be made immediately after the such occurrence have ceased. Furthermore, according to Article 104, the place of payment, so where to pay, it shall be made at or near the place of undertaking. But exceptions. Number 1, when payment cannot be effected at or near the place of work by reason of deterioration of peace and security. Second, when the employer provides the free transportation to the employees back and forth. Third is in the under analogous circumstances. So payment of wages in the bars, night or day clubs, massage clinics, or similar establishments are prohibited except for the workers therein. So the payments could be through banks. But there is also a requisite. So first is that there must be a written permission of the majority of the employees concerned in an establishment. Second, the establishment must have 25 or more employees. And lastly, the bank must be located within a kilometer radius to the bank from the location of the establishment. So payment through the ATM is allowed. Here, who should be the receiver of the payment? So according to Article 105, direct payment of wages, to whom to pay. So wages shall be paid directly to the workers. Siyempre, sila yung naghalo. Siya ang kumita, di ba? It shall be directly paid to the workers. But there are also exceptions. In case of force majeure or special circumstances, payment may be made through another person under written authority where the worker has died. So the employer may pay the wages of the deceased worker to the heirs of the latter through the Secretary of Labor or his representative without the necessity of intestate proceedings after the heirs have executed an affidavit attesting to their relationship to the deceased and the fact that they are his heirs to the exclusion of all others. So if the worker or the employee has died, the employer may also pay the wages to their heirs. So let's move on to the Article 113, the wage deduction. So what are the allowable deductions in the basic pay or the wages? So with the employee's consent, there is 6 allowable deductions. The first one is SSS payments. Second is Medicare. Third is contributions to the Pag-ibig funds. Fourth is value of meals and others. Fifth is payments to third persons with employees' consent. And lastly, the deductions of absences. So without the employee's consent, there are also requisites. So first one is workers' insurance acquired by the employer. Second is union dues, where the right to check off has been recognized by the employer. Third is cases where the employer is authorized by law or regulations issued by the Secretary of Labor. And fourth is the debts of the employee to the employer which have become due and demandable. according to the chapter 5 of the wages in the labor code of the Philippines. So who may set the minimum wage? So there are two. The first one is the regional tripartite wages and productivity board, and the second one is the Congress. So according to the Article 123, there is also wage order. So what is wage order? So wage order is an order issued by the regional board whenever the conditions in the region so warrant, after investigating and studying all pertinent facts and based on the standards and criteria prescribed by the LC, that the regional board proceeds to determine whether to issue the same or not. So the effectivity of the wage order, it shall take effect after 15 days from its complete publication in at least one newspaper or general circulation in the region. So the frequency of the wage order. So wage order is issued by the board may not be disturbed for a period of 12 months from its effectivity, and no petition for wage increase shall be entertained during the said period, except when Congress itself issues the law increasing the wages. So as we all know, the minimum wages here in the Philippines varies. Why? Because due to the factors like cost of living, economic conditions, and local labor market dynamics, the labor code allows for flexibility to adjust the minimum wages based on those factors, ensuring a fair compensation relative to their specific circumstances of each area. So for example, here in Davao City, the minimum wage rate is different from the Metro Manila minimum wage rate. So that's all for the important notes regarding to the basic pay. It is only general since my other group mates will be specifying the topics related on the basic pay. And I only take note what are the important articles regarding to the Labor Code of the Philippines. Thank you.
Hello everyone, my name is Crizel Balasabas and today I will be discussing about the overtime premium pay in the Philippines. So, when we say overtime premium pay, its concept is it refers to an additional pay of 25% of a covered employee's hourly rate for work performed during overtime. It is based on the Labor Code Article 94, Section 3. So, in this, work may be performed beyond 8 hours a day provided that the employee is paid for the overtime work. An additional compensation equivalent to his regular wage plus at least 25% thereof. Work performed beyond 8 hours on a holiday or rest day shall be paid an additional compensation equivalent to the rate of the first 8 hours on a holiday or rest day plus 30% thereof. So this is based on the basic pay of the worker, and they will get 25% of it if they do an overtime, and also 30% if that is a rest day overtime. So for this overtime premium pay, we have eligibility of employees, but this benefit applies to all employees that we called as covered employees, and also there are exempt employees. So listed below are the exempt employees. So first is we have the government employees. So, for the government employees, whether employed by the national government or any of its political subdivisions, including those employed in government-owned and or controlled corporations with original charters or created under special laws. So, for those working in the government, and all either on corporation owned by the government, they are exempted for the overtime pay. And next one is the managerial employees. So for the managerial employees is they need to meet all of the following conditions. There are three conditions in this. First is the primary duty is to manage the establishment in which they are employed or of a department or subdivision thereof. And second is they customarily and regularly direct the work of two or more employees therein. Third is they have the authority to hire or fire other employees of lower rank or their suggestions and recommendations as to hiring, firing, and promotion of any other chance of status of other employees are given particular weight that is based on Section 2 of the Omnibus Rules from Dole Handbook. And The third one is the officers or members of the managerial staffs. So for the managerial staff is officers of members of a managerial staff if they perform the following duties and responsibilities such primarily perform work directly related to management policies of their employer, customarily and regularly exercise discretion and independent judgment, regularly and directly assist a proprietor or managerial employee in the management or establishment of subdivision thereof in which he or she is employed, or execute under general supervision along specialist or technical lines of requiring special training, experience or knowledge, execute under general supervision, special alignment and task, and do not devote more of 20% of their hours worked in work week. And next one is the kasambahay and persons in the personal service of another, such as the yaya, cook, gardener, laundry person, but this shall include any person who perform domestic works. And also, the fifth one is workers who are paid by results. Um, the last is the field personnel. So for the field personnel, this refers to non-agricultural employees who regularly perform their duties away from principal place of business or branch office of the employer and whose actual work of hours in the field cannot be determined with reasonable certainty. So these are actually the exempt employees for the overtime premium pay based on the Labor Code of the Philippines. And that's all for the overtime premium pay topic.
Hello everyone, I'm Fermi Sanya and today I'll be presenting on night shift differential pay in the Philippines. This benefit is crucial for many Filipino workers and understanding its regulation ensures fair compensation for those who work outside standard business hours. Now, we'll explore the purpose of night differential pay, its legal basis and how it's calculated differently for private and government sectors. By the end of this presentation, you'll have a better understanding of your rights and obligations as an employer or employee regarding night shift differential pay. So what is night shift differential pay? So according to Article 86 Labor Code of the Philippines, every employee shall be paid a night shift differential of not less than 10% of his regular wage for each hour of work performed between 10 o'clock in the evening and 6 o'clock in the morning. It is an additional compensation for working night hours, and it also recognizes the challenges of working outside traditional daytime hours. It is mandated by law in the Philippines. So, as many of you know, night shift work can be demanding, and it disrupts our natural sleep cycle, leading to fatigue and potential impacting our health. In recognition of these challenges, many companies offer night shift differential pay. This means employees who work outside traditional daytime hours receive extra pay on top of their regular wages. So the legal basis for night shift differential are Presidential Decree 442, Labor Code, Article 86, which I already discussed, and Republic Act number 11701, Section 1, Republic Act number 11701, an act granting night shift differential pay to government employees, including those in government-owned or controlled corporations and appropriating funds therefore. So in Section 1, government employees occupying position items of division, chief and below or the equivalent, including those in government-owned or controlled corporations, whether the nature of their employment is permanent, contractual, temporary, or causal, shall be paid night shift differential at a rate not exceeding 20% of the hourly basic rate of the employee, as determined by the head of the agency for each hour of work performed between the hours of 6 in the evening and 6 in the morning of the following day, provided that the night shift differential pay provided in this act shall be in addition to and shall not in any way diminish whatever benefits and allowances are presently enjoyed by government employees. Hourly basic rate refers to basic salary rate per hour derived by dividing the monthly rate by 22 working days and dividing the quotient derived by 8 hours. So here are some Key Department of Labor and Employment or DOLE and Labor Code rules on night differential pay. So night differential applies only to hours worked within the designated time frame. So this means employees only receive night differential for hours they actually work during the night shift period. For example, in the private sector, night differential applies from 10 p.m. to 6 a.m., while in public or in government sector, 6 p.m. to 6 a.m. Next, night differential is calculated on the actual hours worked during the night shift. So this ensures fair compensation based on the specific time an employee works at night. So later, I will also provide an example on how to compute the differential night rate. Overtime pay during the night shift is also subject to night differential. So if an employee works overtime during their night shift, they receive both overtime pay and the additional night differential for those overtime hours. Night shift differential is not subject to income tax but is subject to mandatory deductions. This means employees won't pay income taxes on their night differential pay, but it will still be included in their salary for calculating mandatory deductions like SSS, health, and PAG-EB. Employers must maintain records of night differential pay for DOLE inspection. Companies are required to keep accurate documentations of night differential pay calculations for potential inspection by the Department of Labor and Employment. By following these DOLE and labor code regulations, companies can ensure that they are compliant with the law and fairly compensate their night shift workers. So who can receive the differential pay? So employees who are working night shifts are entitled to the pay. However, there are certain exceptions to this rule according to the labor code. So here are the employees who cannot receive night differential pay. Government employees, 6 a.m. to 6 p.m. On-call government employees or mostly uniformed personnel who must serve and or are called to serve anytime like armed forces, national police, firefighters, jail management personnel, workers in retail and service establishment regularly employ a maximum of 5 people only, kasambahay or domestic helpers, employees providing needed for personal service of another person or other people, managerial employee, managerial staff members and or officers, and field personnel and unsupervised employees. Understanding this distinction is crucial to ensure night shift workers receive the appropriate compensation based on the employment sector. Now that we understand the different rates for private and government sectors, let's walk through how to calculate night differential pay. So there are two scenarios to consider: situations without overtime and situations with overtime pay involved. So in scenario one, night differential pay without overtime. So first, we have to compute for the wage for an OT, which is computed by multiplying the hourly wage by the hours rendered, and the differential wage or the differential rate is computed by multiplying the regular pay to the hours rendered times 10%. So the total payment should be daily wage plus night shift differential. So in the scenario 2, night differential pay with overtime. So first, we have to calculate the wage for overtime, which is 25 by multiplying the hourly wage to the overtime premium, which is 25% on the regular hourly wage times hours rendered. So the differential pay, you have to base your wage on the overtime pay times hours rendered times 10%. So the total payment should be all composed of the regular wage plus overtime pay plus night differential. So here's an example in the scenario without overtime. An employee earns a regular hourly rate of 100 pesos and works for 8 hours between 10 p.m. to 6 a.m. So in computing the differential pay, we have to multiply the hourly wage, which is 100 pesos, times to the differential rate, which is 10%, times to the hours rendered, which is 8 hours. And the night differential pay for this example is 80 pesos. So now for the scenario 2, the night differential pay with overtime. So in calculating night differential pay becomes slightly more complex when overtime is involved. For example, is the assuming the employee earns 100 pesos per hour and work for 2 hours of overtime between 10 p.m. to 6 a.m. The computation for the night differential pay would be first you have to calculate for the regular pay, which is hourly wage times hours and labor. That would be 100 pesos times 8 hours equals 800. In step 2, we have to compute for the overtime pay, which is 100 pesos times 125% or the overtime premium times 2 hours. So that would be 250 pesos. So the total pay would be regular pay plus overtime pay equals 1,050. So now in computing the differential, we have to base the wage or the total pay in the regular pay plus overtime, which is 1,050. So 1,050 times 10% times numbers of hours worked at night. So 1,050 pesos times 10% times 2.
Good day everyone, my name is Giselle Kalimhal and today we are going to discuss labor law about holiday premium. So holiday pay, an additional pay provided to a covered employee during regular holidays. Holiday pay is a legislative benefit enacted as part of constitutional imperative that the state shall afford protection to labor. Its purpose is not merely to prevent diminution of the monthly income of the workers on account of work interruption. In other words, although the worker is forced to take a rest, he earns what he should earn, that is, holiday pay. Thus, holiday pay is legally mandated benefit required to be paid to the employee on regular holidays, whether or not said employee work. The amount of holiday pay will depend on whether the employee performed work or not, as explained below. So, the legal basis. So, first is the Article 94, right to holiday pay. Every worker shall be paid his regular daily wage during regular holidays except in retail and service established during employing less than 10 workers. Letter B. The employer may require an employee to work on any holiday, but such employee shall be paid a compensation equivalent to twice his regular rate. And lastly, letter C, as used in this article, holiday includes New Year's Day, Monday, Thursday, Good Friday, the 9th of April, the 1st of May, the 12th of June, the 4th of July, the 13th of November, the 25th, and the 30th of December, and the day designated by law for holding a general election. And daily or monthly paid is whether employees are daily or monthly paid is not relevant. Both daily paid and monthly paid are entitled to holiday. And letter C, employee status is not relevant. As long as they are employees, they are entitled to holiday. Thus, it doesn't matter whether they are regular, probationary, casual, project, seasonal, or fixed term. So next is currently there are 13 regular holidays in the Philippines. So first is the New Year's Day, January 1, Monday Day, Thursday is movable date, Good Friday is movable date, Araw ng Kagitingan, April 9, Labor Day, May 1, Independence Day, June 12, National Heroes Day, last Monday of August, Eid al-Fitr, Eid al-Adha is movable date. Bonifacio Day, November 30. Christmas Day, December 25. Rizal Day, December 30. And general election is movable date. So, general election, the day designated by the law holding a general election is a legal holiday. And letter C, double holiday. A double holiday happens when there are two holidays in one day. For example, since Monday, Thursday is movable, there are occasions when it falls to araw ng Pilipinas resulting in two holidays on the same day or double holiday. And letter D, distinguished from special non-working days. So regular holidays is holiday pay, special non-working days premium pay. So covered and excluded employees, A is government employees, letter B, certain retail and in-service employees, C, kasambahay and person in the personal service of another, D, managerial employees, E, managerial staff, and F is the field personnel. Okay, so next is computation of holiday pay. So there are steps on how to compute for holiday pay. The following are the assumptions. So first is, for example, employee daily rate is 1,000. The covered employee works for 8 hours. So A, no work on a regular holiday. So if there is no work on a regular holiday, a covered employee is entitled to a holiday of pay 100% daily salary. So for example, if your daily rate is 1,000, then since no work is done is 0, so your computation is, your sweldo is 1,000. So letter B, work on a regular holiday. If there is a work performed in regular holiday, a covered employee is entitled to a holiday pay of 100% daily salary plus his wage for that day. So 100%, so for example, 1,000 yung sweldo mo, then plus day wage, which is may work ngayon, so it equals to 2,000. And next, so next is no work on double regular holiday. So if there's no work on a double regular holiday, a covered employee is entitled to holiday pay of 200% daily salary. So situations when an employee is not entitled to holiday pay. If he was absent without pay on the day prior on a regular holiday. Second, if he was absent without pay on a day prior to successive regular holidays like Monday, Thursday, and Good Friday. And number 3, if he was absent without pay on a day prior to his rest day or special holiday that is followed by a regular holiday. And lastly, if he was absent without leave on a day prior to successive regular holidays but he worked on the first holiday, he is entitled to holiday for the following day. So when indulged, interpretation favors labor. So in states in Article 1702, in case of though all labor legislation and all labor contracts shall be constructed in favor of the safety and decent living for the laborer. Article 4, construction in favor of labor. All doubts in implementation and interpretation of the provision of this code, including its implementing rules and regulations, shall be resolved in favor of labor. And Article 4 of the Labor Code provides that although the implementation and interpretation of its provision, including its implementing rules and regulations, shall be resolved in favor of labor. For the working man, welfare should be primordial and paramount consideration. And that's all. Thank you.
Good day, everyone. So I am Juliana May Marmaibe, and today I will be discussing the 13th month pay. So what is 13th month pay? 13th month pay refers to the additional income based on wage required by Presidential Decree number 851, which is equivalent to one half of total basic salary earned by an employee within a calendar year. So the covered employers should pay the 13th month pay anytime not later than December 24. However, the covered employer may pay one half of the 13th month pay required by the decree before the opening of the regular school year, and the other half on or before the 24th day of December of every year. So this is the option of the covered employers, which is stated in the section 5 of Presidential Decree number 851. So employees entitled to the 13th month pay are all rank and file employees, regardless of their designation or employment status and irrespective of the method by which their wages are paid, are entitled to this benefit, provided that they have worked for at least 1 month during the calendar year. So according to the Labor Code, distinguish ranked and file employees from a managerial employee, a managerial employee is defined as the one who is vested with powers or prerogatives to lay down and execute management policies and or to hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees, or to effectively recommend such managerial actions. Therefore, all employees not falling with the definition of the managerial employee are considered rank and file employees and are entitled to the 13th month pay. Who are the employers not covered by Presidential Decree number 851? So first are distressed employers, such as those which are currently incurring substantial losses. In the case of nonprofit institution, those organizations where their income, whether from donation, contribution, grants, and other earnings from any source, has consistently declined by more than 40% of their normal income for the last 2 years, subject to provision of Section 7 of this issuance. Next is the government and any of its political subdivisions, um, including government-owned and controlled corporation, except those corporations operating essentially as private subsidiaries of the government. Next is employers already paying their employees 13th month pay or more in calendar year of its equivalent at the time of the issuance. Next is employers of household helpers and persons in the personal service of another in relation to such workers, and employers of those who are paid on purely commission, boundary, or task basis, and those who are paid a fixed amount for performing a specific work, respective of the time consumed in the performance thereof, except where the workers are paid on piece rate basis, in which case the employer shall be covered by the issuance in so far as such workers are concerned. So the 13th month pay can be in form of Christmas bonus, mid-year bonus, profit sharing payments, and other cash bonuses amounting to not less than one twelve of the employee's basic salary. So it must always be in the form of legal tender. According also to Section 2 of the Presidential Decree number 851, basic salary shall include all remuneration or earnings paid by an employer to an employee for service rendered, but may not include cost of living, allowances granted pursuant to Presidential Decree number 525, or letter of instruction number 174. Profit sharing payments, and all allowances and monetary benefits which are not considered or integrated as part of the regular or basic salary of the employees at the time of the promulgation of the decree on December 16, 1975 is also considered to 13th month pay. So not valid substitutes are free rice, electricity cost, stock dividends, and cost of allowances. For the formula and computation, so we have total basic salary during the year divided by 12 months is equal to the proportionate 13th month pay. So we have example here. So using the basic wage in the National Capital Region at 451 pesos from January 1, 2022 to April 3, 2022, and 466 pesos from April 4, 2022 to December 31, 2022 per day, and a 6-day work week on an equivalent monthly basis salary of 11,199.83 pesos and 11,572.33 pesos respectively. So the solution. So in January, February, March, April, May, June, July, August, September, October, November, December, when you total the salary, the total basic salary earned for the year is equal to 112,275.80 pesos. So 112,275.80 pesos divided by 12, which is 12 months, is equal to 9,356.32. This means that um, 9,356.32 is the proportionate 13th month pay. Some may ask that are maternity leave benefits included in the computation of 13th month pay. So as you can see in the computation, during September, there is a maternity leave and it is not counted to the 13th month pay benefit. Therefore, maternity leave benefits are not included in the computation of the 13th month pay. We have another example. So, for employees with less than a year of tenure, a prorated amount of not less than 1,000 pesos shall be given to them, depending on their length of tenure in the company within the current year. So, this we have basic salary of 20,000. So, the length of tenure in the first example is 1. So, 20,000 times 1 is divided by 12 is equals to the 13th month pay. So the 13th month pay is 1,667. Another is monthly salary of 20,000 with a length of tenure for 6 months. So the 13th month pay is equivalent to 10,000 and so on. So meaning 13th month pay is equals basic pay times length of tenure divided by 12 is equals 13th month pay. So non-payment of 13th month pay. So when an employee does not receive 13th month pay as required by the law, this issue is treated as a matter of concerning money owed to them. So in section 9, it is stated that adjudication of claims non-payment of the 13th month pay provided by the decree and these rules shall be treated as money claims cases and shall be processed in accordance with the rules implementing the Labor Code of the Philippines and the rules of National Labor Relations Commissions. Protection of employees' benefits. According to Section 10, prohibition against reduction or elimination of benefits, nothing herein shall be construed to authorize any employer to eliminate or diminish in any way supplements or other employee benefits or favorable practice being enjoyed by the employee at the time of promulgation of the issuance. In other words, the law is designed to protect current benefits that employees enjoy. It ensures that employers don't use the new rules as a reason to cut back on what they already offer to their workers. So if an employee is getting perks or benefits at work when this law is put into place, the employer must continue to provide those without reduction. So is 13th month pay taxable? So generally, 13th month pay is exempt from taxation. However, there is a prescribed limit to this exemption provided under Section 32B7E of the National Internal Revenue Code, which was amended by Republic Act number 10963 or the Train Law on January 2018. So the amendment stipulates that the 13th month pay and other equivalent benefits shall not be subject to tax for a maximum of 90,000. So therefore, if anything beyond the maximum exclusion rate of 90,000, it must be included in the computation of the employee's gross income for the applicable taxable year. So that's it for 13th month pay. Thank you for listening.
Good day, everyone. I am Marquise Yu, and I will be discussing about leaves under Labor Code of the Philippines, Presidential Decree number 442 as amended. Leave of absence is generally defined as a right granted to officials and employees not to report for work with pays as may be provided by law and as the rules prescribed in Rule 16 hereof. Philippine leave laws provide employees with 6 benefits: service incentive leave, maternity leave, paternity leave, parental leave for solo parents, leave under the Violence Against Women Act, and a special leave benefit for a woman. Weekly rest periods. Under Article 91, right to weekly rest day. First, it shall be the duty of every employer, whether operating for profit or not, to provide each of his employees a rest period of not less than 24 consecutive hours after 6 consecutive normal workdays. Second, the employer shall determine and schedule the weekly rest day of his employees subject to collective bargaining agreement and to such rules and regulations as the Secretary of Labor and Employment may provide. However, the employer shall respect the preference of employees as to their weekly rest day when such preference is based on religious grounds. Under Article 92, when employer may require work on a rest day, the employer may require his employees to work on any day. First, in case of actual or impending emergencies caused by serious accident, like fire, flood, typhoon, earthquake, epidemic, or other disaster or calamity to prevent loss of life and property, or imminent danger to public safety. Second, in case of urgent work to be performed on the machinery, equipment, or installation to avoid serious loss which the employer would otherwise suffer. Third, in the event of abnormal pressure of work due to special circumstances where the employer cannot ordinarily be accepted to resort to another measure. Fourth, to prevent loss or damage to perishable goods. Fifth, where the nature of the work requires continuous operations and the stoppage of work may result in irreplaceable injury or loss to the employer. And under the other circumstances analogous or similar to the foregoing as determined by the Secretary of Labor and Equipment. Under Article 93, compensation for rest day, Sunday or Holy Week. First, where an employee is made or permitted to work on his scheduled rest day, he shall be paid an additional compensation of at least 30% of his regular wage. An employee shall be entitled to such additional compensation for work performed on Sunday only when it is his only established rest day. Second, when the nature of the work of the employee is such that he has no regular work days and no regular rest day can be scheduled. He shall be paid an additional compensation of at least 30% of his regular wage for work performed on Sundays and holidays. Third, work performed on any special holiday shall be paid an additional compensation of at least 30% of the regular wage of the employee. Where such holiday work falls as on the employee's scheduled rest day, he shall be entitled to additional compensation of at least 50% of his regular wage. Fourth, where the collective bargaining agreement or other applicable employment contract stipulates the payment of a higher premium pay than the prescribed under this article, the employer shall pay such higher rate.
Good day everyone, good day sir. I am May Agbas and I will be discussing about Service Incentive Leave under Labor Code of the Philippines, Presidential Decree number 422 as amended. According to Article 95 of the Labor Code, Service Incentive Leave, first, every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. Second, this provision excludes current beneficiaries, those on a 5-day vacation leave, employees in less than 10 employee establishments, or those exempted by the Secretary of Labor and Employment. Third, the grant of benefit in excess of the provided herein shall not be made a subject or arbitration or any court or administrative action. It means that all employees will receive 5 days of leave credits each year under the provision if they have worked for the company for at least a year. These credits are transferable, so employees can use them for paid time off, for sick days or vacation. Second slide is the benefit applies to all employees except first, government employees, which whether employed by the national government or any of its political subdivisions, including those employed in government-owned and or controlled corporation with original charters or created under special laws. Second, person in the personal service of another. Third is the managerial employees. If they meet all of the following conditions, first, their primary duty is to manage the establishment in which they are employed or a department or subdivision thereof. Second, they customarily record and regularly direct the work or two or more employees therein. And third, they have the authority to hire or fire other employees of lower rank, or their suggestion and recommendations as to hiring, firing, and promotion or any other change of status of other employees are given weight. Fourth, officer or members of a managerial staff if they provided the following duties and responsibilities. First, is a primarily perform work directly related to management policies of their employees. Second, customarily and regularly exercise discretion and independent judgment. Third, a regular and directly assist a proprietor or managerial employee in the management of the establishment or subdivision thereof in which he or she is employed. Execute under general supervision, work along specialized or technical lines requiring special training, experience, or knowledge. And lastly is execute under general supervision, special assignment, and task. And last is do not devote more than 20% of their hours work in a work week to activities which are not directly and closely related to the performance of the work described in paragraph 5.1, 5.2, and 5.3 above. Fifth is a field personnel, and those whose time and performance are unsupervised by the employer. 6 covered and excluded in service incentive leave is those already enjoying these benefits. 7 is those enjoying vacation leave with pay for at least 5 days. And lastly, those employed in establishment regularly employing less than 10 employees. Service incentive leave has benefit. It is once covered employees complete 1 year of service, they are entitled to 5 leave credits with full payment. So annual or prorated. There is a confusion about how service incentive leave credits are given to covered employees after at least 1 year of service. Companies may give 5 service incentive leave after their work anniversary, while others issue is a fraction of the 5 service incentive leave and issue the remaining service incentive leave on a piecemeal or prorated basis. This confusion stems from the lack of an explicit law or regulation. Labor courts have consistently applied the 5 service incentive leave on the first year or work anniversary. They prorated the first service incentive leave credits for the second year, which is has the illustration of I have showing in this slide. It is a service incentive leave is replenished annually with employees entitled to a new set of credits on a prorated basis after the first 5 credit are granted. Interpretation of 1 year. The 1 year of service means that the covered employees has rendered service for at least 12 months, whether continuous or broken, counting from the start of his employment. The phrase whether continuous or broken means that the counting of the 1 year is continuous even if the employees did not work for several weeks or months within the said year. For example, the maternity leave period availed for women employees are considered or included in the counting for 1 year. The same goes for paternity leave and all other kinds of applicable leaves, as well as in situation where employees are unable to work through no fault of their, such as being hospitalized due to an illness or accident. Usage. Service incentive leave is a discretionary leave credit that employees can use for sick, vacation, or personal reasons. Employers cannot apply leave credits without employees' consent, as employees may reserve them for specific occasion. So, a service incentive leave can be convertible to cash. It is annual service incentive leaves are required to be converted to cash at the end of the year or upon the termination of employment due to just causes or separation from the service due to authorized causes. So the summary of my topic is first, service incentive leaves are leave credits extended to covered employees who may want to use them whenever they take a leave from work so that they remain paid during such absence from work. Second, there are 5 service incentive leave credits given to an employee who has rendered at least 12 months or 1 year of service. Third, the leave credits may be used for whatever reason. Fourth, the employer is required to pay the cash equivalent of the unused leave credits. And lastly, the service incentive leave credits replenish yearly.
Good day everyone, I am Arisa Rose Rosero and I will be discussing to you the maternity and paternity leave. Let's start off with the maternity leave. Under Republic Act 8282 as amended by the Republic Act 11210, it states here that the pregnant female employees, whether single or married, are extended leave credits with full pay to be used in every instances of pregnancy, miscarriage, or emergency terminations of pregnancy, regardless of the frequency. So who can avail the maternity leave? The benefit is designed to grant a female employee with leave credits to be used during or after her pregnancy. So enjoyment of maternity leave cannot be deferred but should be availed of either before or after the actual period of delivery in a continuous and uninterrupted manner. So what are the benefits of the maternity leave? First is the 105 days of maternity leave with full pay. It also states here that there is an additional 15 days for solo parents as defined in the Republic Act number 8972. It also has the option to extend 30 days without pay and also the option to allocate up to 7 days of the maternity leave to the child's father or the alternate caregiver. Note that the grant shall be in every instances regardless of the frequency of childbirth, miscarriages, and emergency termination of pregnancy. So the benefit is not convertible to cash because it means that the covered employee is unable to convert cash with the leave credits because the purpose of the maternity leave is to afford the covered employees the opportunity to attend to her pregnancy, her delivery, and her recovery. So what are the conditions for entitlement of maternity leave? First is she must be a Social Security System or SSS member who has paid at least 3 monthly contribution in the 12-month period immediately preceding the semester of her childbirth, miscarriage, or emergency termination of pregnancy. Second is she shall have notified her employers of her pregnancy and probable date of her childbirth, which notice shall be permitted to the SSS in accordance with the rules and regulations it may provide. So what is the penalty for non-compliance of the employers? So if a female workers give birth or suffer a miscarriage or emergency termination without the required contributions having been remitted for her by her employees to the SSS or without the latter have been previously notified by the employers of the time of the pregnancy, the employer shall pay to the SSS the damages equivalent to the benefit which said female members would otherwise have been entitled to. So the paternity leave under the Republic Act number 8187, it is an act granting the paternity leave of 7 days with full pay to all married males in private or public sectors for the first 4 deliveries of their legitimate spouse with whom he is cohabiting and for other purposes. So who can avail the Paternity Act? First is we have the married male employees existing of employer-employee relationship. Second is the whose lawful wife experienced childbirth, miscarriage, or abortion. C, they must be cohabiting at the time of the delivery, which means that both of them shall live in the same roof. D is may only be availed in the first 4 deliveries of the wife. So who are the covered employees? The covered employees are the married male employees. The covered male employees must be legally married to their legitimate wife. Thus, paternity leave benefits under Republic Act 8187 does not cover male employees who are not legally married to their romantic partners in a boyfriend or girlfriend relationship. So the employment status of covered males is also irrelevant, as well as how covered males are paid is also irrelevant. So what are the benefits of the Paternity Act? So under Section 3, for the purpose of this act, the paternity leave refers to the benefit granted to a male employee, allowing him to not report to work for 7 days but continues to earn the compensations therefore, on the conditions that his spouse has delivered a child or suffered a miscarriage for purposes of enabling him to effectively lend support to his wife in her period of recovery or in the nursing of their newly born child. The benefit shall only apply, of course, to the first and 4 deliveries of the male employee's legal wife. So the leave credits is equal to the basic salary including the mandatory or integrated allowances. The pay shall not be less than the minimum wage. The same as the maternity leave, the benefit is also not convertible to cash for a reason that the paternity leave credit is only to afford the covered male employees the opportunity to attend to his legitimate wife after pregnancy. So when may it be availed? So the paternity benefits may be enjoyed by the qualified employee before, during, or after the delivery of his wife, provided that the total number shall not exceed the 7 days working for each delivery. So the benefit should be availed not later than 60 days after the date of the said delivery. So what are the conditions for entitlement of paternity leave? One is he is employed at the time of the delivery of his child. Two is he has notified his employer of the pregnancy of the wife and their expected date of delivery. C is his wife has given birth, suffers a miscarriage, or an abortion. Next, last slide is what is the penalty for non-compliance of the employer. So any person, corporation, trust, firm, partnership, association, or entity found violating any provision of this rule shall be penalized by a fine not exceeding 25,000 pesos or imprisonment of not less than 30 days nor more than 6 months. That is all for the maternity and paternity leave. Thank you. And I hope you learned something.
Good day everyone, I am Sheila Marie Aniga and I will be presenting the parental leave for solo parent. Under Philippine labor law, solo parents are entitled to specific benefits. And these include parental leave for solo parents, which is covered by Section 8 of the RA 8972, also known as the Solo Parents Welfare Act of SAN. As stated in the provision, solo parents are given a forfeitable and non-cumulative parental leave of not more than 7 working days with full pay. This benefit is given to enable them to fulfill their parental obligations when their physical presence is required or beneficial to the child. So, who are those qualified persons to be classified as solo parent? According to Section 4 of RA 8972, solo parent refers to an individual who falls under any of the following categories. First, a parent who provides sole parental care and support of the child or children due to a birth as a consequence of rape, even without final conviction, provided that the mother has the sole parental care and support of the child or children, provided further that the solo parent under this category may still be considered a solo parent under any of the categories in the section. B. Death of the spouse. C. Detention of the spouse for at least 3 months or service of sentence for a criminal conviction. D. Physical or mental incapacity of the spouse as certified by public or private medical practitioner. E. Legal separation or de facto separation for at least 6 months, and the solo parent is entrusted with the sole parental care and support of the child or children. F. Declaration of nullity or annulment of marriage as decreed by court recognized by law, or due to divorce subject to existing laws, and the solo parent is entrusted with the sole parental care and support of the child or children. Or G. Abandonment by the spouse for at least 6 months. Second, spouse or any family member of an overseas Filipino worker or the guardian of the child or children of an OFW, provided that the set OFW belongs to the low or semi-skilled worker category and is away from the Philippines for an uninterrupted period of 12 months, provided further that the OFW, his or her spouse, family member, or guardian of the child or children of an OFW falls under the requirements of this section. Third, unmarried mother or father who keeps and rears the child or children. Fourth, any legal guardian, adoptive, or foster parent who solely provide parental care and support to a child or children. Fifth, any relative within fourth civil degree of affinity of the parent or legal guardian who assumes parental care and support of the child or children as a result of that abandonment, disappearance, or absence of the parent or solo parent for at least 6 months, provided that in cases of solo grandparents who are senior citizens but who have the sole parental care and support over their grandchildren, who are unmarried or unemployed, and 22 years old or below, or those 22 years old or above but who are unable to fully take care or protect themselves from abuse, neglect, cruelty, exploitation, or discrimination because of a physical or mental disability or condition, or 6. A pregnant woman who provides sole parental care and support to the unborn children or child. Those aforementioned are just a qualification of a solo parent. For them to be entitled to the parental leave, they must meet these conditions. First, they are solo parent defined under RA 8972. Second, they have rendered service of at least 6 months. Third, they have presented a solo parent identification card. And lastly, they have notified their employer of the availment thereof within reasonable time. However, the parental leave for a solo parent can be limited and terminated. Under Section 16, a solo parent shall not lose his or her status as a solo parent if the other parent provides occasional assistance and/or seasonal gifts that do not meet the legal requirement of support under the Family Code of the Philippines, provided further that the absence of a valid and legal marriage between the mother and the father of a child or dependent does not automatically entitle either individual to the benefits under this Act, if the factual circumstances demonstrate that the parental care and support are shared.